Business Matters. The title suggests many things. The important issue is the world revolves around business, society, organizations, individuals, and even religion survives and thrives because of business. Business has to encompass not just financial commodity and service transactions. It has also to include welfare, justice, empowerment, environmental, and other issues too. Every week, Business Matters will delve into aspects of business that impact our lives. We will seek out extraordinary and ordinary people who have done extraordinary things. Facilitators, educators, and entrepreneurs will be invited to inspire and enlighten our listeners. Join Anwar Mullah for an interactive show and find out what really matters in business.
نحمد ونصلي على رسوله الكريم أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another Business Matters program on Radio Al Ansar. Business Matters brought to you by the Minara Chamber of Commerce. Tonight I have a very good friend in the studio with me, and he needs no introduction to Radio Al Ansar. In fact, he said to me just now that he'd been on a few days ago. So a very, very warm welcome to Radio Al Ansar to Aslam Mayat. Aslam is an attorney and conveyancer, certificate in tax law, certificate in business rescue, chairperson of the Income Tax Appeals Board from July 2003 to July 2008. Tonight, our topic is going to concentrate around property, and one of the reasons that we have got Aslam in is because there's a property seminar coming up very soon, or hosted by the Association of Muslim Accountants and Lawyers, better known as AMAL. And Aslam himself plays a very, very important part in AMAL. In fact, I think he's keeping the ship afloat at the moment. So Aslam, Assalamu alaikum firstly, and welcome once again to Radio Al Ansar.
Wa alaikum salam. Thanks for having us.
Okay. Aslam, tell us a little bit about the seminar. It's scheduled for this Saturday, the 24th of June. And I think it's one that you're quite excited about, and I'm sure you must have got lots of people attending. So you want to touch a little bit about what it's about, and how would somebody who hasn't yet heard about it be able to attend?
Okay. I think it would be nice if callers, listeners sent in questions, which would be, we could answer later on in the program.
Once we get into the topic, we'll ask them to send us some questions and call in. And tonight will be free consultation from Aslam. Don't get free consultations from Aslam in a hurry, so please make use of that. But first, tell us a little bit about the seminar.
Okay. Look, AMAL is the Association of Muslim Accountants and Lawyers, and we've got quite a strong team of accountants, lawyers. This Saturday, the 24th of June, between 10 o'clock and midday, AMAL will be hosting a hybrid, virtual, physical and virtual talk on property law. We've got a chartered accountant and a lawyer to cover law, tax issues as well. The fee is for members 200 Rand, AMAL members, and for non-members 500 Rand. But really, I think it's very, very cheap for what benefit people will get. And it won't only be for accountants and lawyers. I think anybody involved in property, I think the listeners of your program, they all clued up. But even people who don't know too much and want to learn, they'll learn a benefit a lot. And even the experienced accountants and lawyers, I think, will learn a lot because it's comprehensively covered. AMAL offices are at 45th Cutting. That's in the Masjid complex. And payment details can be obtained from email info@amal.coza. So that's fairly easy, I think, info@amal.coza. And the telephone number 031 207 3381. As I said, it's a minimal cost because we're trying to get as large an audience as possible. It's comprehensive. It'll cover income tax, CGT, VAT, share block, sectional title, Insolvency Act, Companies Act, trusts, should you buy in a trust or a company or, and many, many other issues as well.
Okay, Aslam, so that's this Saturday, 24th of June. It's 10 a.m. to 12, so it's a 2-hour seminar.
Yeah. And it'll be
concentrating
simply explained, so people will be able to understand. We'll have slides and so on as well.
Okay, so even a person like me could be able to understand. That's a 2-hour seminar at the AMAL offices. 45th cutting, that's in the Masjid complex this Saturday, 10 to 12. Aslam, the topic of property, I mean, why would you have chosen something like property at the moment? Obviously, some people have been asking some questions.
Yeah, look, everything, people are involved in property all the time. These days, even something as simple, or what should be simple, as buying a house. Now, there's CGT implications, estate duty implications, there's long-term estate planning. You might want to protect it from creditors. You might want to keep it secure for, going down generations. If it's a house, you don't want it to be sold and distributed. So there's a whole host of consequences. And now, depending, if you say you buy it in a trust, now there's admin costs. Since 1st of April, they've come out with this beneficial ownership declaration that has to be made. Consequences of not complying, 10 million rand and 5 years imprisonment. So there's various crazy things. But that's just a property, a residential property. You want to make sure that maybe after you die, your wife has security, protected from creditors. So even everything is not so simple as just signing an agreement. You need to think about it beforehand and decide. Maybe consult with your accountant, consult with your lawyer before you plunge in. And it's very easy. You sign the agreement, but it might find out later on that, look, this was the wrong thing to do. There's and then when it comes to commercial properties, then it becomes far more complex because you got VAT, CGT, all sorts of things. You could pay something now. You think you're saving money by buying it in a certain way now, and find out later on the tax consequences down the line are huge.
Absolutely. I suppose with CGT or capital gains tax, it's about primary residence and things like that.
Primary residence, you'll get an allowance. So you get an allowance if you buy it in your own name. If you bought it in a trust, you wouldn't get that allowance. Then there's 7C, income tax donations. So there's many complexities which one has to navigate.
Yes, and I suppose it also depends on the purpose for which you're buying the property, whether it's a residential or commercial, and then you would have to structure whether you buy it in a company, buy it in a trust, buy it in your personal name. Yeah. As you said, all sorts of implications further down the road, because when one is buying a property, it's not for 3 months or 6 months. It's generally a very long-term holding.
That's your biggest investment normally. For the normal person, that's your biggest investment. And it's not just tax consequences. Long-term planning, security, protecting it from creditors, making sure your family gets it and benefits. So there's a host and it's not a one-size-fits-all. A young person has very different needs from somebody who's much older. So there's a lot of thinking that needs to go into these things.
Okay. Again, we said if the studio lines are open, if anybody wants to tap Aslam's brain on any legal issues for tonight, and I don't think we can restrict it to just property, but we'll say any legal issues. So the number in the studio, 0861904904, and I repeat that, 0861904904. The WhatsApp number, it's 06090411056. Again, I repeat that, 06090411056. And one can call in again also at 208-1601, but rather call on the studio number, which will come directly through to us. We've just gone into the month of Zil Hijjah. The moon has been sighted, first of Zil Hajj. So, tonight's, I think, be the first program in the month of Zil Hajj. Wow. So that confirms that Eid al-Adha will actually be next week, Thursday, here in South Africa. Eid in Saudi Arabia will be on Wednesday. The day of Arafat will be on Tuesday. So exciting few days ahead for all of those who are making qurbani. And I hope, Aslam, you've trimmed your nails and I see your beard is well trimmed. So you've obviously done all of that before the month of Zil Hijjah has set in. I would be in deep trouble if I didn't thank you and your good wife Shamima for the naan katai which you brought along to the studio. Would you, Shamima, thank you so much for the naan katai. I'm going to have that, dip it in tea and have it like naan katai should be had. So thank you, Shamima, for the naan katai. Aslam, we're talking about property, but I just want to digress a little bit. Recently, there's been a lot in the news about Muslim marriages in South Africa. What is the exact position regarding Muslim marriages at the moment?
Yeah, I think, look, how you are married affects your proprietary regime. So Absolutely. It's very much related to property. It's not, everything interacts. It's not divorced from property, and it's a very important question. The Concord has given Parliament time to pass legislation. Until that legislation is passed, nikah marriages are regarded as law. So all the consequences of a South African marriage will apply to nikah marriages. So they're not regarded as marriages yet, but all the consequences are exactly the same and will apply, except that on the termination, they'll be regarded as out of community. Whereas if you married in terms of South African law, you default into in community. So for all intents and purposes, South African law marriages apply. You got maintenance, you got inheritance. So, this is very, very directly related to property and proprietary regime. So although you married, a termination will be regarded as out of community unless there's an agreement to the contrary. Okay. So if the parties agreed to be married in community, then that's what would apply, right? But in the default situation, you'll be married out of community, which is opposite to the South African law position. But other than that, all the consequences will apply. And, Muslim marriages have been subject to so much litigation, more than Hindu and Jewish marriages, which are also not recognized. So until legislation is passed, we're going to continue to have this uncertainty relating to marital regime. And, whether the marriage is valid, whether the divorce nikah has taken place, these things will continue to haunt us. So really, I cannot emphasize the importance of entering into a contract, whether it's pre-nikah or after nikah. Enter into a contract to clearly define these issues.
So when you said whether it's pre-nikah or post-nikah, Generally, I'm saying we've been told that we should enter into an anti-nuptial contract at the time of marriage.
Yeah, but that's when you entering into a civil marriage.
Yes.
If you're married in terms of civil, you default into in community. Yes. So that's why they say go and do the contract, so you'll be married out of community.
Which is the Islamic way of doing things.
Yes. Generally, default, yes, no arguments. Right. You can have certain Islamic partnerships you can agree to, but if you don't, yes, it's out of community.
Okay. So the Constitutional Court ruled that all South African law consequences apply to nikah marriages. And they will be regarded as out of community of property, and let's just distinguish, because generally a marriage will be as if it's in community of property. So that would be the distinguishing factor for Islamic marriages. So where's the uncertainty?
The uncertainty was when they said unless they entered into a contract.
Okay.
Right. Now, that contract doesn't have to be written.
Yes. Yeah.
Right. So, unless you enter into an agreement to the contrary, which now puts us attorneys in business, because, despite this thing having gone through the High Court, it then went to the Constitutional Court, there were a battery of lawyers. In my respectful view, the addition of that, I don't think was properly thought out. Because, let's just put it to you, consider a scenario, a husband dies leaving 4 families.
4 families.
4 families.
Okay, good luck to him. Yeah.
Each widow contends that they had an agreement that they would be married in community of property.
It doesn't have to be written.
It doesn't. That was the agreement. Now the husband dies. Dead men tell no tales,
yeah.
right? And they say, now, how do you have 5 people married in community of property to each other? It's inconceivable.
Okay.
So that's why I don't think in my understanding, they haven't thought this through properly.
Would there not be an onus on each of them to prove that?
Let's say they prove it.
Okay.
Let's say, in fact, that was the case.
Right.
Then what? How do you have 5 people married in community of property to each other? And then a creditor pitches up and says, he owed me so much money. Would he be able to attach 4 estates?
Yes.
And suddenly they'll say, no, we were married out of community of property. So we need legislation. And until then, enter into a contract, define the issues and so on. But as I say, if you enter into a contract and all of you all say you're married in community, it's a disaster.
Okay. So the courts have agreed that Muslim marriage will be regarded as if married out of community.
Unless there's an agreement to the contrary, and therein lies the devil. Right.
Okay.
Now, I'll just give you an example. In the Cape, the husband had 2 families.
Right.
And he had issues with the first wife and he issued the talaq.
Right.
He died. The second family says he died without a will. So the second family says we inherit everything. The first wife says no.
On what basis does she contest it?
We reconsumed marital relations during the iddat period, which negates the iddat, which negates the nikah.
So that's getting really complicated.
Right. So that's her evidence. The husband, nobody can gainsay otherwise. The court accepted. Now, the MJC issued a talaq certificate. The court overruled and said that certificate is invalid because they accepted her evidence. So because there's no rules which says when, there's no registration process.
So the estate had to devolve equally amongst 2 parties then, amongst the first family and the second family.
Yeah, well, what happens in interstate succession is that each wife gets 250,000 or a child share, whichever is the greater.
Right.
Right. So in this case, depending how many, he's got 2 wives and how many children he had, and let's say it was a very big estate, they'd all share equally. If you have 4 wives and R1 million, the 4 wives get 250 and the children get nothing.
Right.
And one wife might have 5 kids, other wife might have no kids, one might be young, it makes no difference. That's what the thing. That's it, yeah.
Okay, so the other critical thing that comes out of this is make sure you die with a will.
Well, look, Islamically, you're supposed to have a will in any event because otherwise South African law applies.
Right.
Yes, so
you don't want that to happen.
Yes, so you need to have a will, and yes.
Okay. If you've just joined us, it's the 1st of Zilhajj. Yes, the moon was sighted, and we in the 1st of Zilhajj. Alhamdulillah, and we end the Business Matters program on Radio Al Ansar. With me is attorney Aslam Mayat. We were talking about property and then we digressed to Muslim marriages, but we're going to concentrate the rest of this program more on property, also considering that Aslam, who's very much part of AMAL, Association of Muslim Accountants and Lawyers, are having a seminar on Saturday all about property. I'm sure it's going to be quite an exciting seminar. Aslam, just before we went off air, I asked you a question about if a Muslim man dies interstate. You did touch on it a little bit, but just to conclude on that one, as you said, it depends on the contract, marriage contract. If a Muslim man dies interstate, how would his estate devolve?
Yeah, well, let's say he's regarded as out of community.
Right.
Then everything would belong to him. You'd look each spouse would get 250,000 rand or a child share.
Right.
So depending on the number of children,
Depending on the size of their estate.
size of the estate, if it's large enough, that the wives and the children will all get an equal share. Right?
Yeah, but if he leaves an Islamic world, then it will be completely different.
It will be correct. It will be different. Each wife will share an eighth.
Will share an eighth.
Share an eighth. The balance. Remember, the parents also get.
Yes.
So if he's got
if they are surviving parents.
if surviving parents would each get, and then the balance would get divided amongst the children, boys and girls 2:1. Predeceased children would not get. Their descendants would not get.
Their lineage will be cut out. Yeah.
Unless you provided for it specifically, and you can provide specifically up to 1/3 to non-heirs.
Right.
And grandchildren of, would be non-heirs, right?
Okay, so Aslam, I think the critical thing here is to emphasize the fact that, firstly, before you get married, think about the contract and enter into. Would you advocate entering into an anti-nuptial contract?
Anti-nuptial contract, or it's a nikah. Anti means before marriage, so
right.
Anti-nikah contract.
Okay, but some sort of
a contract.
A contract that would mean that your estate will not devolve according to South African.
No, that you need a will.
Absolutely. Okay, sorry, that you need a will. But you need an anti-nuptial
to determine what your marital proprietary regime is. That's what it is.
Okay. Which would also play a part in your estate as
correct.
well.
Then there's no dispute as to who it belongs to. Yes.
Yeah. So if you're married. If you do not have an anti-nuptial contract and you married community or property, it's a simple half of it goes
half
to
is each spouse and half to yourself.
Which is against the tenets of Islamic law, because according to Islamic law, only 1/8 goes to the spouse.
Yeah, on the assumption that everything was yours. You built up everything. She didn't participate in thing. There wasn't an agreement where you all had some sort of partnership, etc. Yeah.
Okay, so that's but the critical thing is that the Islamic law 1/8, common law 50-50. So big difference.
50-50 plus.
50-50 plus. So you need to make sure that
you still get your plus 250 and a child share.
I'm saying that it just to kind of put forward the fact that one needs to have an anti-nuptial contract so that you don't have a situation where your estate is now going to be distributed against the tenets of Islamic law.
Correct. Yes.
Okay. So okay, we've got a question that's come through, and I'm just going to read this. It says, Salam, I have a question with regard to property purchase. We are helping our domestic to buy a house in KwaMashu. The seller selected the lawyer. Now, remembering this question has come through from the buyer, right? So the seller selected the lawyer. 50% was paid to the lawyer since the payment date. The buyer and the seller are having difficulty getting hold of the lawyer. The lawyer is registered with the Law Council. What legal channels should we follow to try and recover the money and change conveyances? So here it seems like the lawyer has ducked.
Okay. Before I answer that question, I'll just touch on a few other points which could be raised in this question. They say they bought it for a servant, so it's possible that the property could be worth less than $1 million, right?
Okay.
And if it's worth less than $1 million, there would be no transfer duty payable.
Right.
So there's a huge saving, or there's conveyancing cost, but no transfer duty.
So transfer duty only applies on property over $1 million.
Over $1 million. Right. Then,
sorry, would that be residential and commercial?
Anything.
Any property.
Any
okay.
property.
Great.
Where transfer duty is, because a property could be either transfer duty or VAT.
Right.
Now, this is a residential property. It's transfer duty. If it's under $1 million, there's no duty payable. It's nil.
Right.
The other thing is that, possibly the house could be worth less than 400,000.
Okay, we don't know because the
we don't.
The question didn't say what was the value of the property.
Servant area. So I'm just so people think.
Okay.
So if it's under 400,000, then there's no rates payable either. There's a total rates exemption.
Okay.
Right? So just getting that out of the way.
Right.
To answer the question, finally getting there, the appointment of the conveyancer, the parties did an agreement, and by contract they've appointed the conveyancer.
Generally, I'm saying generally, okay? Who would appoint the conveyancer? Is it a buyer or the seller?
Generally, you'll find that the seller would be appointed, and this is a good thing. But at the end of the day, it's what the parties sign.
Okay.
Right?
Okay.
So
but you're saying generally it's the seller.
Would normally want to have he's got control of the situation, because the person could be delaying is the person who has to come up with the money.
But I've always found this to be a bit of a problem, because generally the conveyancer's costs are paid by the buyer, yet the seller decides on who the conveyancer is.
Well, at the end, it's an agreement, and the parties must agree. Now, just to get to this, the parties agreed to appoint X.
Right.
It's very easy for the parties, if they both, from this question, they're both unhappy with X, for them to now say, we are changing our agreement and we are appointing Y.
Okay, I've just got confirmation the price is 220,000, which means that the rates exemption would apply. Okay.
So the parties, it's very easy for them to change the contract and appoint somebody else. Right. The problem in this case
is the 50%.
Is that the money has already been paid.
Correct, the 50% has already been paid.
Now, to recover that money, one would have to lodge a complaint with the LPC. There's a law society, which all but the new name is LPC. There's a fidelity fund. But that now is the whole process. They'll do an investigation, they'll call him, and so on. It's the whole process. Whereas, in the meantime, the poor two parties are stuck. So there's a delay in getting that out, but that's the recourse. Is they won't lose their money because the Fidelity Fund guarantees it, but there's a process to go through to be able to access it. Yeah.
But generally, when one is paying something like this, a deposit for a house into a lawyer's, it would normally go into a lawyer's trust account, right? And one.
Well, look, we're assuming the worst.
Right.
It could be just a bit of tardiness, a threat to report to the law society, or for the law society to send a letter to this fellow might immediately get him moving or her moving. I don't know whether it's a he or a her, but it might have immediate results, and the whole problem could be solved. And then I would suggest they change the lawyer and get somebody else. If he's already done work, he'd be entitled to charge some fee, but whatever it is, that can be negotiated.
But the question clearly says that since the payment date, the buyer and seller are having difficulty getting hold of the lawyer.
Yeah. Let's assume he's done nothing, and they should report it immediately to the law society. It might have and send a copy to him that, look, here's the complaint
we're not taking this lying down.
Yeah, we lodge it with the law society. That might immediately produce the results.
Right.
And at that stage, you tell him, okay, fine, we're not happy with you. The buyer and the seller have now changed. Pay the money out to some other conveyancer.
Okay.
So and maybe this time the purchaser's conveyancer.
Yeah, unfortunately, because now the buyer could turn around and tell the seller, you chose the...
Well, look, at the end of the day, whoever chose, there was an agreement, they both signed and appointed somebody. Right. They need to change that.
Okay, interesting. Okay, let's move on a little bit about property. And assuming I'm buying a property which is a primary residence, or my first residence, should I buy it in my own name, or should I buy it in the name of a trust? Now, I know you said there's no one size fits all here, but generally, what would be your recommendation? Yeah,
look, it all depends now. What is the purpose of you? Your purpose and what you're trying to protect, right? So, let's say you are in business and you could be subject to risk.
Okay.
Now, if you buy it in your own name, creditors can attach it.
Yes.
Because anything can go wrong in business, or you might sign surety ships or something, and your one asset which you don't want affected is at risk.
Okay.
So that might be a good reason to say, look, I put it into a trust, so that's safe for my creditors.
Yeah, but again, let's go back to thinking Islamically, which we have to.
Yes.
From an Islamic perspective, if you're owing the money and somebody is claiming money from you, whether it's your residence or your car or whatever, you need to now downscale and pay out whatever you can pay out. Unfortunately, and I say this in a very general perspective, today we're having people that get liquidated, but their standard of living doesn't drop. They're living better lifestyles after liquidation than they did before liquidation, and that shouldn't be the case. If you are owing the money and that house has to be attached, I'm saying that house has to be attached.
Point taken, but maybe they should attach other assets of yours.
Okay.
Rather than
the house.
going for your house. Then there's estate duty, long-term estate duty planning, which you could peg your estate by if you put it into a trust.
Right.
So your estate is pegged, and then the growth doesn't take place in your name. So you'd pay less estate duty.
Okay.
Right? Then you get the primary residence. If you put it on your own name, you get a primary residence allowance.
That's now the other argument.
That's the benefit of putting it in your own name. So let's say you've got no creditor problems. It could never be creditor problems. Or on the other hand, you'd have enough assets to pay from other things. The benefit is you'd get the primary residence allowance on a CGT if you sold it later on. Then also, if you die, now I know there's a whole Islamic angle to this and so on, but if you die, then you're instead of the property going to various people, it can be retained in one entity, which avoids it being, one person getting up and saying,
just splitting up the house.
Splitting up the house and a multiplicity of owners. Anyone can say, look, I want it sold, to avoid that as well.
And then very often the person who resides there is kind of pushed from pillar to post and doesn't have a roof over her head.
Now, each of these things, as you say, now look, you got to look at the Islamic angle to see whether it complies. It can be done, but it needs somebody who understands the position, because there's certain schools that allow for leases and usufructs. Hanafi does not allow it. Right, but the other schools, Maliki does. So it's not as simple as that, but there are things that can be done. I mean, if you take, you mentioned this thing about trusts, and we're talking about Islamic law. Let's say you've got a wife and daughters. Now, if you die, then it would go also to your siblings as well. That's a possibility.
Yes, if you don't have any male kind of dependents or in that male children, then your brothers and sisters will also become heirs.
Right. So somebody might say, hold on, this is my house. I need to protect my wife and my daughters.
Right.
So how do I overcome that? Now, Islamically, you can. Okay. You can form a trust, and you can stay there until you die.
Right.
Your wife can stay there until she dies.
Okay.
Your daughters can stay there until they die.
Yeah.
And so on. You can go down generations. But the capital has to be retained, and the ultimate beneficiary has to be charity.
Okay.
Right.
Okay.
So, I mean, that's just one example of how one can marry the thing and sort out Islamically a certain concern that somebody has.
I think the concern, a lot of people that don't have male children have this concern that if something happens to me, my brothers and sisters will get the bulk of what is there, and my wife and children are going to be prejudiced. That's a very real concern.
Yeah, so there are ways, I have a bit of difficulty where people say, go and sign an Islamic will, and you think that miraculously all your problems are solved. You actually need to go to somebody who can explain to you exactly what the consequences are, what you can do Islamically, what you cannot do Islamically, and then you make your decision based on that. Because it's not as simple as just taking a standard will, signing it. I mean, just the simplest example of signing a standard Islamic, you don't see them saying that if your child predeceases you, his children are not your Islamic law heirs.
Correct. Right.
Now, when you explain that to somebody, he says, no, I want to be able to protect them from that 1/3, which you're entitled to do.
From the 1/3 portion only.
From the 1/3. Now, most of the times, the 1/3 is even more than the share of that child.
Depending on how many children they have.
Yeah. So, but at least they'll get something instead of nothing.
Nothing. Yeah.
And every single person you explain that, they're horrified. They say they didn't know that, and obviously they want to cover that.
Yeah.
But you sign a standard Islamic will, it doesn't provide for that. It doesn't even alert you to the fact.
No, but I think the for me the important thing here is when you're consulting, then consult with a lawyer that knows the legal position, but also more importantly knows the Islamic standpoint as well. So you need to be consulting with a lawyer that understands both.
Even the alims and so on, they also would be able to guide you.
The alims are well versed.
But all I'm saying is, go and consult. Don't just say standard will, sign, and I'm very happy.
Buy one standard will from the Al Ansar bookshop. Sign it.
And think you because you might not be doing justice to your family, and God has given you akkal, and the akkal is to be used.
No, I think fair point. But and also the bigger the estate, the larger amounts involved, the more one should consider all of this. So
whatever.
The thing is, nobody kind of wants to talk about debt and expects to die. That's the thing. But we all know there's only one certainty in life, and that's debt. And basically, we need to make provisions from an estate planning point of view. Critically, have your wills in place and do your estate planning properly.
Yes, you must have an Islamic will, but take advice before you sign.
Yes. Okay. I've got another question that's come through. It says, Assalamu alaikum. I just want to know, my husband is late. Is there transfer duty from my husband to my name? The property is being transferred at the moment.
Not in an estate, there's no transfer duty.
There's no transfer duty?
No.
Okay, so would be a general rule in an estate, or is it only between husband and wife?
No, that's a general rule.
So no estate, no transfer duty.
That's correct.
Okay.
So just to give you, let's say you're 90 years old,
right,
and you're about to kick it. You could, instead of transferring that property to, let's say, your son,
right,
you're going to pay transfer duty.
Yes.
So rather, give it to him in your will.
Okay.
For South African law purposes.
Right.
But before that, you make the niyat. You can do it in writing that, son, this thing belongs to you.
Okay.
It is yours.
Right.
I don't own it.
So you've given it in your lifetime?
I've given it my lifetime. You could kick me out tomorrow, that's fine. Right? But I've given it to you. And then to conform with South African law, you bequeath it. So you save your transfer duty on that.
Okay, so you because it will only transfer after the person has passed away.
In terms of South African law, but Islamic law, you've covered the thing. It belongs to the son, and that has to be a genuine thing. You can't say, "Oh no, I'm taking," because it doesn't belong to you.
If you give it to him, you give it to him.
It's his, yeah.
And then you need to obviously tell the others.
But now, you know your son. You know he's not going to kick you out, whatever, and you saving a whole lot of money.
Okay, but for sake of this question that's come through, in this case there will be no transfer duty because it's an estate.
It's a bequest, yes.
Okay, that's great. We're talking about transfer duty a little bit. I think last question for me for tonight is the issue of transfer duty against VAT. So that's something that, especially when it comes to commercial property, we kind of come across quite often.
Okay. If you're a vendor, if you're a VAT vendor,
right,
and that property forms part of your VATable enterprise, because you could have something, a VAT vendor could own something which is not part of his VATable enterprise.
Sure,
yeah. But if it's part of your VATable enterprise, if you're a VAT vendor, you charge VAT.
Okay.
If you're not a VAT...
Or if you're buying from somebody, provided both parties would have to be VAT registered.
Hold on. You're jumping the gun now.
Right.
If the seller is a VAT vendor,
right,
and that property forms part of the VATable enterprise, then VAT is payable.
Right.
If the seller is not a vendor, transfer duty is payable.
Okay.
Right. So you only look at the seller. The
Right.
seller determines whether transfer duty is payable or VAT is payable depending on his tax status.
Okay.
Okay. Now you're looking at the purchaser. You could pay, VAT is payable at two rates. VAT is payable at the standard rate of 15%, alternatively 0%.
Okay.
So if you buy a leasing enterprise as a going concern and you take over all the leases and you are also a VAT vendor, you can zero rate the transaction.
Okay.
Right? If you can't zero rate the transaction, then you'll pay the VAT and reclaim the VAT.
Sure. Yeah.
If you are not a vendor, you've paid the VAT and it's gone bye-bye.
Right. Sure. Yeah. Okay. So in I suppose, again, general rule, if the property is of a low value, perhaps better transfer duty, because up to R1 million there is no transfer duty, but you'd still pay VAT.
But it depends on the seller, whether the seller is a vendor or not. It doesn't matter what the amount is. You got to look at the seller.
Okay. Yeah, I suppose that's why you need people like yourself to kind of guide you through all of these complicities.
Yeah, look, it's not so simple. You need to get some advice beforehand. And as I say, it can get very complicated. And this program will be, the talk that we're having, is going to break it down quite simply so people, if you know what to look for.
Yes.
And then you know whether, hey, hold on, here I need to go and get advice before I do something. Here, okay, it's covered. I don't need to worry about it. I can handle it myself. Look, here I need to check with my attorney. Here I need to check with the accountant as well. It'll give you that understanding of
what role would an estate agent play in this? Because I mean, literally, they want to make the sale. They want you to sign on the dotted line. But from your experience, I mean, how well versed are the estate agents? Because they would be able to guide and advise as well. Because sometimes you sign on a dotted line, for example, in your personal capacity, and 2 days later you decide or you realize that you should not have signed in your personal capacity. You should sign on basically as a trust, or put it into your wife's name, or something else. And then it becomes quite difficult to change once you've signed on the dotted line.
Well, unless both parties agree, you can't change.
You can't change, yeah.
You can't change. Look, you get good lawyers and you get good estate agents. But, that's not their field.
Right.
Accounting is not necessarily a lawyer's field. Some lawyers do understand both aspects, or at least know that, hey, I need to go and check with an accountant on this aspect, because it needs that type of advice. Generally, I think, look, as you say, I mean, the person's trying to do a sale. Some of the people are very junior. And as I say, it's not their field. That's not their job. You need to get, I mean, if you want to know what defects there are in that property, you don't ask your lawyer or your hairdresser, you ask an accountant. Architect. I'll get an architect to look at the thing and say, look, what defects, what's wrong with this property, give me that advice, and so on. So you need to get advice from the right people.
So consult with the specialists.
Yes, if it's that person's field, get advice from them. Yes.
Okay, Aslam, I think we've reached the end of tonight's program. Jazakallah for coming in. Thanks once again to Shamima for the naan kata, which I'm very looking forward to having as soon as I get home. And inshallah, we'll chat again, and all the luck with the seminar on Saturday.
Yeah. And as I say, if there's accountants, attorneys, estate agents, people involved in property who've got property portfolios, they'll all benefit hugely from this talk.
Excellent. I wish a great turnout, and I'm sure it's going to be an absolute benefit to all those concerned. Thanks, Aslam, for coming in. It's been a pleasure chatting to you. And inshallah, we'll meet again soon on one of our future programs, but I'm quite sure about that. So Jazakumullah khair, and inshallah we'll meet again. I'm not sure about next week, being close to the big days of Zil Hajj, whether we are or we aren't going to be having a program. But if we are, then I'll inshallah be in the studio with another exciting guest, and looking forward to seeing you again on the Business Matters program. The Business Matters once again brought to you by the Minara Chamber of Commerce. With that, it's wassalamu alaikum wa rahmatullahi wa barakatuh.